few notes here in the recording that might be somewhat of a different delivery than what I have with the PowerPoints and notes, where you can read and see the corresponding PowerPoints. So again, I strongly suggest that you look over those notes and the PowerPoints, but you're certainly welcome to listen to these recordings as well. Chapter 5, Civil Rights. So we can see the distinction here between Chapter 4 and Chapter 5. We just finished with Chapter 4, looking at civil liberties. So here we're focusing on the rights among groups. I would think for each one of you, you'd like to view yourself as an individual, and of course you are an individual, but there are also groups that you belong to. So think about those groups and how they're represented, what types of protections might they need, have they needed in the past, how are there ways to ensure that the groups that you belong to also give you an opportunity to be equal and to be competitive in our society. So the interpretations of these rights come from the law, and the group that interprets the law based on its constitutionality would be the Supreme Court. And so the Supreme Court has a considerable amount of power when it comes to the interpretation of civil rights, just as it did in the chapter before on civil liberties. So here we can see that in recent years, the Supreme Court has made some decisions that involved voting, involved protections or changes in the representation for groups. So certainly read about that and the status of the Voting Rights Act on pages 170 to 172. Supreme Court case, for example, in 2015 ruled against gerrymandering. Gerrymandering is in the news today, and it's a major issue dealing with how the districts for the House of Representatives or the state legislature would be drawn in a particular state. And so this is a major issue, something that's focused on these pages. So look that over. Are we in a case that we need to consider race less, ethnicity less in our society because we are overall as a people, we don't focus on those issues? That's one of the questions that's being raised. Are we in fact a race-blind society today? That's what Chief Justice John Roberts has said, that we are a post-racial society. In your own notes, in your own time, evaluate that statement, evaluate that outlook. Do you agree with it? Do you think we are in that situation? Or are there cases in which the government in some form needs to continue with protections and enforcements of policies and laws that can ensure more equality? Part of the argument has been that since we elected an African American to be president, that we are in a post-racial society. You can, again, make your own evaluation if that's a good enough standard to determine that are we in fact in that category. Are there differences, though? And this is from a fantastic book. I would strongly recommend it for anyone who would like to read more about our society and about economics in our society. It's called Evicted, deals with the housing practices in major cities. And so here you can see what happened in the economic downturn of the 2000s and how some people were impacted more than others overall in the aggregate based on somebody's ethnic background. So again, fantastic book, would strongly recommend it if you would like to read something there about economic and housing policy in the United States. And of course, something that captures a lot of attention is people who are killed by police. This is a few years old, of course, the factors here. It's a tough job to be a police officer. I think everyone would agree with that. What types of issues should be considered in these overall standards on how the police approach someone who is perceived to be by them to be a threat? And so here we have a couple of sources that I've made references to in this class in some capacity. And there are overall some differences in this approach of this policy. At least that was the case just a few years back. So former slave Frederick Douglass just summarized it that there is always going to be a struggle. There is no struggle, there is no progress. So we're still struggling, and hopefully we're still progressing on these issues. And they don't go away. Slavery is not something that ended in 1865 in the United States, and unfortunately there are still dreadful situations for people that they find themselves in these situations, and maybe they put themselves this way in a vulnerable position, perhaps not always that they put themselves that way, and it doesn't really matter if they did, but they now find themselves incapable of being able to defend themselves, and they're going to be taken advantage of in horrible ways. So that continues to still unfortunately happen. This is 8 years ago, so it's been a while, but still not that long ago. Time magazine makes the conclusion that there's actually more slaves today than at any point in human history. We oftentimes think about civil rights as a black-white issue, and there's plenty of reasons to make that conclusion, but there are certainly other groups that we perhaps know more of than others, depending on our own family background, our history, and our geography. Many of us here in Oklahoma are familiar with American Indians. Many of you taking this class have a background with this ethnic group. You may be part of this ethnic group. But we can see here that it wasn't that long ago. It's not even 100 years ago still, in which American Indians were U.S. citizens. So you get a sense there of that struggle for the American Indian. Women didn't have the right to vote, and will be 100 years next year, but it was not until then that women had the right to vote. And I think there's other groups that we can consistently come back to and say, what is how should they be treated? And of course, the flip side to that is to say, when is there an acceptable form of discrimination? That's a tougher one to deal with. But are there times in which we say it's acceptable and necessary for society to not allow the same type of right or protection? Age discrimination brings up a very important one. Are there times in which you say there's a limit to the age that someone can be to do a particular job? And that's where your chapter explores that issue of acceptable discrimination. So the heart of a lot of the debates that we have on this issue come from the Civil War, and without a doubt, you just spend your own time exploring the basis of the Civil War, and it comes back to time and again the issue of slavery. And so that's worth noting as you review this issue here, and the basis of 3 amendments that come pretty much on the heels of the Civil War. So you have these Civil War amendments, 13th, 14th, and 15th Amendments. So focus on those that you see here in your text, the years and the overall impact on society. There would, of course, be backlash to these Civil War amendments. A big area there was the Jim Crow laws, that states would make its decisions on how to interpret these amendments and then also how to enforce segregation laws within the state. So you would have, as this sign suggests, what was referred to as the separation between colored and white people in many states. You also have then this viewpoint that whites, could political parties say, make a determination that only white people could vote in that party? Are political parties private clubs? And the conclusion has been that they're not, that people have a right to join a political party. But you have to have the courts to enforce that in the criminal justice system. You had to be literate to vote, so you could enforce that to make it very difficult for people to vote based on the literacy test. And then you had to pay a tax to vote. And certainly people with very little disposable income are likely to go and pay than to go vote. So it tells us there that voting is a major issue, and then we can see the ongoing process of diminishing that right to vote. Supreme Court then also upheld segregation in the case of Plessy v. Ferguson, and we see the phrase separate but equal. When you read about this case, you'll see that. You could have blacks in one railroad car, whites in the other car, as long as the facilities were separate but equal. Generally, that was not the case, but that was the explanation as to how you could, in fact, have segregation. So this comes back to Chapter 11. We'll be covering that in a few weeks down the line, but you had some interest groups that came forward that were opposed to this ongoing segregation and treatment of groups as second-class citizens, not having the right to vote, limited places where they could stay, all those issues. And so just kind of keep that in mind when we get to Chapter 11, the importance there of interest groups in changing our society. And so for women, a major issue was to ensure the right to vote. And that's what suffrage means, extending the right to vote. So this was something that women protested for and took some considerable risk in many cases. In the late 19-teens and early 1920s. Segregation started the process in many ways in our social fabric, areas such as the military, professional sports teams. They started to end segregation before you had a legal movement within the government. So Harry Truman, as president at the end of World War II, he enacted an executive order to end segregation among the military units, and that you would then integrate with black and white soldiers in military units and other ethnic groups as well. So it is an important irony, to think about as World War II was being carried out. The United States fighting this war against fascism and Japanese imperialism would be fighting this war with segregated troops for the most part. Then you have this process here of using the courts to end segregation in public education. It's been a long-going process, lots of evidence to suggest that it's still occurring. But at least from a legal point of view, de jure segregation, you'll read about that, segregation by law, it's supposed to be ended. And it ended here with the Brown family in Topeka, Kansas. And Linda Brown, the little girl that you see here in this picture, believe she passed away just last year. This was a case that came out in 1954 and was to try to end this particular activity here. And the courts ruled that you could not have legal segregation in the school system. It's been a lengthy process. It's not been easy, was extremely difficult in the 1950s, and certainly many of the students who were alive at that time who carried out this, tried to carry out, were actually ultimately successful in carrying out desegregation in Little Rock, Arkansas, where this picture is taking place. Had some really difficult experiences, but were very courageous in trying to end segregation. What really was successful in ending segregation was the Civil Rights Act of 1964. Certainly read about that, a lot of details there using the power of the federal government, as we talked about with Chapter 3 in federalism, using the power of federal government to enforce desegregation, carry out that process. There still would be ways for states to not fully enact the civil rights laws, but it made it more difficult for that to happen. And so here's some important areas to read about in these pages on the Civil Rights Act. So make a point of looking that over. And this is a court case not really focused on in your text, but this was the case that challenged the 64 Civil Rights Act and made the declaration that it was in fact constitutional. It was not a violation of the 14th Amendment. We focused on the 14th Amendment when we talked about Chapter 4, equal protection under the law, and we brought that up in some other areas already. The Commerce Clause was used to ensure, or to be interpreted that the 64 Civil Rights Act was constitutional, and the part of national police power to legislate moral wrongs, as you see there. And I'm getting this information from a brilliant scholar in his book on constitutional law, which we have at the NEO Library, Kermit Hall. And you want to read a summarization of almost any case in the United States up until the death of Dr. Hall, which was a few years back now. He has brilliant reviews there of that, so I would urge you to look that over sometime if you have any kind of question about a legal case. So women's rights also are involving civil rights, and they're involving interpretations of the law. In some ways, you can think about some of the arguments that are made about culture and the study of American culture, any culture for that matter. So you look at how people are portrayed in the media, in movies, books, and then just look at what they have to wear. Generally, they don't perhaps have to, but it's become culturally accepted to wear certain types of items. And you can see here in many ways for women, just the garments they had to wear would be restrictive on how they were shaped and what they could do. And so in a way that serves as a symbol of what the life was like for women for many years. So when you look at the ways to interpret the law, and again, raising an interesting question, when is there acceptable discrimination? So for women, you have an intermediate scrutiny, and so generally this involves women. Doesn't necessarily always do, but in many cases. So if there's a question of women being discriminated, the burden of proof through intermediate scrutiny, it's partially on the government and partially on the challenger. Where you have a strict burden of proof focuses on race and ethnicity, meaning that it's rarely acceptable for that type of discrimination, and the burden of proof is on the government only. So in a firefighter test, is it only the burden on the government to say that they have to have discrimination? And the argument here would be an intermediate test, that there was also the challenger has to explain the burden. This comes back to this question: are there times in which there's an acceptable form of discrimination? So the firefighter test would be demanding. You have to have a certain amount of stamina and strength to be able to do the job. Is it acceptable that you have to have those things? And if you can't, you're not going to become a firefighter. I think most of us are going to be able to conclude those are acceptable forms of discrimination. You have to have upper body strength, and that would be discriminatory against anyone, perhaps more so women, that would not have the suitable amount of upper body strength to be an effective firefighter, and so would not be able to pass the test. But the firefighters wouldn't need to change the test in order to keep that discrimination possible. There's unofficial segregation as well. In fact, that probably happens more so when we look at how neighborhoods are designed and how neighborhoods are built primarily based on economic capabilities, and that may keep some groups out more than others based on the economic standings overall in society. So there's no law that has a segregation, but you still have that. So are there times in which that would be an attempt to try to change that segregation? The attempt to do that has by and large been busing. It's not been very successful, but that has been what's been used to try to change that form of discrimination, that form of segregation. So here we can see, and it's very important to focus on these court cases here and the overall theme of extending civil rights, giving protections of groups to more groups, giving that protection to more groups. So here we can see how that's been used. And so look at those different organizations there, different groups, and ways to try to ensure that. Ending segregation among Latino Americans in schools, ensuring that Asian Americans born in the United States are citizens, that's extended to everyone now. Ensuring that Native Americans learn in their own native languages in school, that's been extended to many other groups. Ensuring that people with disabilities have access to public buildings, have access to education, and extending the opportunities for people in the LGBTQ society. And there we have the question of ageism. Are there times in which people are being discriminated against based on their age? Is Barbie treated differently at 50 than she would have been at 22? Are there acceptable forms of discrimination here on age? That once you reach a certain age, you could not continue on with that job? That's one of the questions for you to consider. Are there, in fact, acceptable forms of discrimination? And we know that that goes on the other side too, acceptable forms of discrimination for young people. We have other changes that are occurring in our society, and changes occurring in Oklahoma. Brittany Novotny ran for the state legislature in 2010, 8 years ago. And this is a person who is transitioning from being a man to a woman. And so we see that occurring in our society. That's an issue that perhaps many years ago wasn't really focused on, but it is an issue in our society today. And we've had people transition in the genders and at the high school level. And so we have this issue raised, we brought up in Chapter 4 on the right to privacy, constitutionality of sexual acts between same-sex couples, and how that is also then used to bring about a level of equality among homosexual couples as we see with heterosexual couples. And then we have this issue, we had this discussion last week on who should be admitted into a particular college. and some of the questions raised there on who's qualified and how do you determine that qualification. Focus on this court case here, University of California versus Bakke. And having quotas was found to be a violation of the 14th Amendment. And so, however, there is still this ongoing question of using racial consideration for admission. So a bit of perhaps conflicting ruling, which is now 40 years old, but we still see perhaps the challenges for universities to get the best, most qualified students and yet also have diversity within society. Is that important? Is that an important goal? So how do you accomplish both of those goals? And recently, you've had, in the last 15 years, as we can see there, cases involving the University of Michigan, which have had an influence in other states as well, other universities. So yes, you try to have a diverse student body. However, how you go about trying to determine who can get into the university. If you have a point system, as you can see there in the second bullet point, was found to be unconstitutional. So a lot of conflicts there on trying to determine who's most qualified to get into a university. So again, as we mentioned here, we're focusing on what are the rights of individuals in civil liberties, chapter 4, and here we're looking at the rights of groups in civil rights. All right, we'll stop there. Our next area of discussion and review will be on public opinion, measuring public opinion, and we'll be covering that soon.